and today we're going to discuss fragmentation of international law. Well, to begin, I would like to mention that my main source for this presentation was the report of the International Law Commission called Fragmentation of International Law, Difficulties Arising from the Diversification and Expansion of International Law. So just to clarify, the International Law Commission is a specialized body from the United Nations, which has a body of experts that helps develop and codify international law. So to begin the presentation, I would like to make a little survey in which you can participate. I'm gonna share the link in the chat so you can enter. And it's a question for you, which is, what is the law applicable in times of war? And we have three options: international humanitarian law, international humanitarian law and human rights, and lastly, the United Nations Charter. So you can enter the link that I left in the chat, and you can vote for the answer you think it's right. I'm gonna give you some minutes so you can decide. Currently, IHL and human rights law is winning. We have a 40-60. It's only growing. Okay, so we have the results. Okay, so 22 people voted. 8 claimed that the applicable law in times of war, it's IHL. 13 said IHL and human rights law. And 1 person said the United Nations Charter. So what is the correct question? It's gonna be a very lawyer answer to it, which is, it depends. Why is that? Because in terms of the application of international humanitarian law and in times of war, first you have to consider in which setting you are, whether you are in jus ad bellum or jus in bellum. In terms of jus ad bellum, it's the conditions that justify the use of armed force or war. This includes the prohibition on the use of force, and in this case, it does apply the United Nations Charter. However, in times of war, which is jus ad in bellum, one would say that international humanitarian law is the one that applies. However, have you also considered that, for example, environment law also applies in times of war? Well, this was the view of the International Court of Justice in the advisory opinion on the legality of the threat or use of nuclear weapons. In this advisory opinion, one of the questions that the court had to answer was whether environmental law treaties applied in times of war or if they didn't. And what the court mentioned, which is pretty interesting, is that states must take environmental considerations into account when assessing what is necessary and proportionate in the pursuit of legitimate military objectives. So indeed, in times of war, international humanitarian law applies, but also human rights law could apply, and even environmental law. And this is a glimpse of fragmentation. I'm of the view and this is the same view that the International Law Commission has, which is that fragmentation of international law is in itself not an issue, and it has both pros and cons. So what is fragmentation? We know that there are many systems, subsystems, bodies in international law. And it seems that there is no homogeneous system of international law, but rather that are different partial systems, and therefore it makes international law an unorganized system, right? Because it might seem that there are erratic parts and elements which are so differently structured that one couldn't, or one only could hardly speak of a system existing, right? That is the issue of fragmentation. And it has its cons because there's a danger of having conflicting and incompatible rules, principles, and institutional practices. But it also reflects the rapid expansion of international legal activity and how, in the modern state of affairs, international law is covering many different topics and subject matters. Another example of this might be the request for an advisory opinion regarding climate change. Because, for example, in this case, it has been brought up before the International Tribunal for the Law of the Sea, the International Court of Justice, and the Inter-American Court of Human Rights. Of course, they all have a different specialized system and a different perspective on this matter. For example, IDLOS might take into account the environmental perspective on it, the International Court of Justice, the responsibility of the states, and lastly, the Inter-American Court of Human Rights will take into account the human rights implications of climate change. But it does pose a threat that they might give conflicting standards or set of rules for states. And this is not only a matter of climate change, because in terms of responsibility of states, we have first the International Court of Justice, then we have the regional human rights systems, in which we have in Europe, we have both the European Convention on Human Rights and also the European Court of Human Rights. In America, we have the American Convention on Human Rights and the Commission and the American Court of Human Rights. In Africa, we have the African Charter on Human and People's Rights, both the Commission on Human and People's Rights and the African Court on Human and People's Rights. We have IDLOS, we have the Dispute Settlement Body of the World Trade Organization. So all these different organs pose a threat in terms of having a conflicting system. So to address this matter, to address the matter of fragmentation, we have discussed the issues, and we're going to dwell more into the causes of fragmentation. Then we're going to talk about the possible solutions of fragmentation and some conclusions on this matter. So one of the first times that fragmentation was brought up, it was by a president of the International Court of Justice. And he mentioned that to solve the fragmentation issue, the International Court of Justice could have a special role in this matter and be the one that solves when there is a conflict on a standard, on a rule of law, that they could be somewhat of a super court. However, this came with a lot of critiques by scholars and by others, because in international law, there hasn't been an intention for there to be a centralized organ. And this is in turn very different from an internal legal system. For example, here in Colombia, we have, of course, separation of powers. And for example, we have a set of high courts that do not have a hierarchical system. However, do have a constitutional court. And there was an issue regarding the application of some rule regarding criminal law. And there was an interpretation given by the Supreme Court of Justice that was different from the one given by the Constitutional Court. And in the case of Colombia, it was said that since the Constitutional Court was interpreting the Constitution, that here those have a hierarchical higher standard, then in this case, the interpretation of the Constitutional Court should be given more weight. Well, that doesn't happen in international law because there are many different institutions that work in different matters. Second of all, we have specialization. So it seems to be that there is an autonomy on the topics discussed in international law. And for example, it has been criticized that environmentalists could neglect state responsibility, or that human rights advocates will be unaware of the rules concerning treatment of aliens. Because it seems that more now than ever, there is a specialized body dealing with certain specific topic in a matter, which makes difficult the application of general international law as a system. And we're going to talk about this a little bit more later, but because it is a system, even in the most specialized body, general international law keeps applying. Then we have the enlargement of scope of international law. And as an example of this, we have cybercrime, because cybercrime is a matter that has been addressed by international law in this century, and it reflects the enlargement of what is applicable nowadays to international law. We had in 2001 the Budapest Convention, the Convention on Cybercrime, which started only as an European initiative, and then the treaty became open to other states that wanted to be parties of it. And this very same year, in the United Nations General Assembly, they have approved a draft concerning the Convention Against Cybercrime. So, for example, this shows us how the scope of international law is only getting bigger. As well, very recently, this very same year in 2024, the World International Intellectual Property Organization, WIPO, has adopted a draft on a treaty concerning intellectual property, genetic resources, and associated traditional knowledge, which is an issue that has been long been discussed in international law, but only until this very same year, there is now a treaty which will require applicants of patents to disclose both the country of origin and the source of genetic resources, and also whether that claim invention is based on traditional knowledge from indigenous people or from a local community. But for example, regarding intellectual property, here in Latin America, in the Andean Community, we already have a law covering that original law. Which brings me to the next cause of fragmentation, which is parallel regulations. And parallel regulations regards an issue in which there might be a different set of regulations over the same topic. It could be either at the same level, at a universal level, or it could be at a bilateral one or a regional one. That is not an issue per se. The issue is when there may be a contradiction upon them. Although in 2000, the International Tribunal of the Law of the Sea dealt with that in the Southern Bluefin tuna case concerning Japan and New Zealand. And in this case, they were discussing the application of the Convention on the Conservation of the Southern Bluefin Tuna, a very specialized treaty, and UNCLOS, the United Nations Convention on the Law of the Sea. However, the arbitration tribunal regarding the application of both conventions stated that there is no reason why the application of one should impair the application of the other one, but rather that in the same conduct, a state could violate different sets of rules in international law. Because in this case, Japan was arguing that the Southern Bluefin Tuna Conservation Convention was lex specialis and lex posteriori, so therefore UNCLOS couldn't be applied. So this brings us to what are some possible solutions when there is a contradiction in international law regarding fragmentation. So we have several possible solutions, but I will start by stating that it will mainly depend on the situation and on the context of it. The first one that we have is that we are in a case where there are imperative norms, which are norms that are accepted and recognized by the international community of states as a whole, for which no derogation is permitted. These are the case of jus cogens norms, in which we have the prohibition of aggression, the prohibition of slavery and slave trade, of genocide, of racial discrimination, of apartheid and torture, the right of self-determination. These are all norms that in the case of a conflict between one set of norms and jus cogens norms, we know that jus cogens norms don't allow any derogation. Also, this is the case of the United Nations Charter, in which it is specified that under Article 103, in the event of a conflict between the obligations of the members of the United Nations or under the Charter and their obligations under any other international agreement, the obligations under the Charter shall prevail. So this states that in any given situation of conflict between the United Nations Charter and any other set of norms, the United Nations Charter shall prevail. And this also extends to binding decisions such as the one made by the Security Council, which is an organ of the United Nations. Second of all, we have a principle of general law, not even only international law, but general law, which is lex specialis derogat legi generali. And this is simply when we have two or more norms that deal with the same subject matter, priority should be given to a norm that is more specific to a given situation. This might apply in the same treaty if there are two provisions that seem contradictory. If one is more specific, then that one should apply. But this can also apply, for example, to a treaty and to an international principle. It could also apply. But also, we can use this principle when we have a conflict with a norm of a custom, nature, and a principle. So it doesn't necessarily have to be a treaty, but it can be other norms of an international nature. However, we do have a very specific case, which are the self-contained regimes. So these are a specific case of lex specialis, and there are systems or subsystems of rules that cover some particular issue that it would be differently addressed from the way it would be covered under general law. So we have human rights law, World Trade Organization law, and European law. And you have to take into account that, for example, in these self-contained regimes, they have both a different standard in terms of their primary norms, but also in terms of their secondary norms. So what they usually have is that they would have a different standard in terms of state responsibility. However, it might seem that they are very specific, that they are autonomous, but in those cases, general international law still applies because it has or it provides two functions. First of all, it provides background to fulfill aspects when the operation is not specifically provided by it. And we have an example here, which is the dissolution of a state. So this is to say the termination of a state, the disappearance of a state. In the case of a dispute before the World Trade Organization dispute settlement body, there will be a question of what would happen. There will be a succession of a state, what will be the fate of any claims that were brought before that state or that state was bringing before the dispute settlement body. And in this case, one could apply rules of general international law regarding state succession. Another function that general international law might have is that when there is an issue or a substantive or procedural nature, we could apply, for example, the Vienna Convention on the law of the treaties, or the rules on state responsibility that might be relevant to those situations. And we have two cases, we have many more, but here is an example. We have two cases in which some tribunals address this very same issue. Regarding human rights, we have the European Court of Human Rights, which has stated that the European Convention on Human Rights cannot be interpreted in a vacuum, and that the court must be mindful that in this case, they have to also apply the relevant rules of international law, that they have to take them into account, and that the convention should be, as far as possible, interpreted in harmony with other rules of international law, of which it forms a part, including those, in that case, relating to the grant of state immunity. Also, in the World Trade Organization, it was noted that we take note that Article 3.2 of the Dispute Settlement Understanding requires that we seek within the context of a particular dispute to clarify the existing provisions of the World Trade Organization agreements in accordance with customary international law rules of interpretation of public international law. However, and this is really important because what they're saying here is that, yes, general international law still applies. In this case, customary international law still applies to economic relations between World Trade Organization members. However, they will only apply to the extent that they don't contradict the obligations that members of the World Trade Organization have under their treaty and their agreements. That is to say that if there is no conflict, general international law could apply. When there is a conflict, of course, there should be a prevalence of the World Trade Organization agreements. And we have a very important tool in general international law, which is the Vienna Convention on the Law of the Treaties, which brings us to some pretty interesting solutions. And I think that the most important of them, which is systematic integration, which is in Articles 31 and 32, in which you're going to find ways to interpret a treaty. And these articles, what they try to do is that a treaty works in a given context. And the objective of systemic integration is to help us apply that treaty in that given context, understanding other rules that might apply. And for example, here we have some positive and negative aspects to take into account, and is that in terms of the application of systematic integration, we have to revise whether general principles of law were excluded or not, or if they were pretended to also be applicable to that set of context. It is not usual that in international law and that in a treaty there is an exclusion of a principle of international law. However, it could be a possibility. Also, it has to be reviewed whether the parties had the intention to refer to, for example, customary international law and general principles of law for the questions that the treaty itself did not resolve in express terms. And here we have another very interesting solution, intertemporality. I remember this one specifically because when I did Jessup in 2021, there was an issue concerning intertemporality because there was a succession of states. And the question was whether at that time when there was a dissolution of a state, what was the customary international law applicable to that given moment. So intertemporality makes us apply the norms of a given time to that specific situation, but also understanding that there could be subsequent developments. So this is a tricky one to apply because you have to bear in mind what was the rule applicable at the moment of the conduct you are assessing, but also you have to, for example, if you're applying a treaty that was concluded in 1974 and you're applying it to a situation that happened today in 2024, you have to also bear in mind that there has been a subsequent development in that matter, and that you cannot only apply in itself the treaty from 1974 without taking into account what has been, for example, the state practice in that very same matter, because international law is intended to keep addressing current issues and therefore continue to make some type of evolution. And here we have also another principle of international law, which could come as a possible solution to it, which is lex posteriori derogate anteriori, which states that a subsequent norm derogates the one that was before it. When there is an issue or a conflict of law, one could apply this, but there are some exceptions. Because, for example, we have in the Vienna Convention of the Law of the Treaties, Article 30.4, a provision that states that the state that is a party to two incompatible treaties is bound vis-a-vis both of its treaty parties separately. So this is the case in which a state has concluded two sets of treaties and they are incompatible between one another. However, under the Vienna Convention of the Law of the Treaties, it is stated that you can apply, for example, lex posteriori derogate anteriori, so you can apply the one that was concluded later and not the other one. No, because that state is bound by both of them. So there are some exceptions to that norm, because also you could be applying a jus cogens norm and a treaty that was concluded today, but this jus cogens norm cannot be derogated, so you couldn't use this principle of international law to solve a contradiction between those two systems. Or there is also another standard, which is when there is a treaty that was concluded by some parties, and there is another treaty concerning other matter with other parties, maybe one of them is in both of them, that party cannot apply lex posteriori derogate anteriori, because there are different parties to the treaties. If there is a conflict of norms, that said party is bound by both of them, because there is no identity in the parties. If we have a treaty concerning the conservation of certain part of the sea, a certain island in the sea, and you conclude a treaty in 1994 stating that there will be no economical activities in that sector to protect it, but then in 2002 you decide that, well, why don't we make a treaty which we allow some activities? You can't apply lex posteriori. You cannot if there is not an identity of parties in those two cases, because you would have two different sets of obligations that are owed to different states. But if it's between the same parties, you could say that this is a development on the first treaty, and that they believe that given the current situations, it is necessary to provide some exceptions to that general provision that was in the first treaty. It could be a possibility. So if there is an identity of parties, you could apply lex posteriori derogate anteriori. If not, that state would be bound by those two sets of obligations. So, through this presentation, we have discussed the issue of fragmentations, its causes, its possible solutions, but what could you do when there is an issue of fragmentation presented to you? First of all, you have to address it in every particular context to decide what is the best solution to it. Because there might be some relevant hierarchies that apply to a specific case that couldn't be applied to another one. For example, what we first saw regarding the application of international humanitarian law, there might be some cases in which the environmental consideration could be more or less important depending on what is the context of the conflict, of that situation, of the military target. So every solution that you may address, it has to be given by the specific case at hand that you have. Secondly, you have to pay attention to the role that the Vienna Convention on the Law of the Treaties has as a basis when there is a conflict in an international law set of rules. Because the Vienna Convention on the Law of the Treaties provides many tools to address these issues. The first one being systematic integration. You have to take into account the context, the situation, because what the Vienna Convention on the Law of the Treaties tries to pursue is the harmonization of norms, and a possible solution in which it wouldn't be necessary to choose one system over the other or one provision over the other, but rather, and this is the final conclusion, which is to remember that international law, it is a system. And this is an advice also for Jessup and for life in general, which is that remember that whenever you're applying international law, you're applying a system, which is not composed by different subsystems which do not interact with one another. That is not the case. The case of international law is that every little regime, sub-regional regime, interacts with one another. So therefore, if you're applying a convention regarding economic provisions, you also have to take into account environmental considerations or human rights considerations, which usually are included among these treaties. So you have to remember that the system, that there is a system of international law, and that in the same situation, many different provisions can apply. And it is important that all of them are considered to bring a solution that is comprehensive to the issue at hand. With that, I thank you for your time and for being here. And I have a QR code with my LinkedIn if you want to reach out and talk about anything international law related.